I mean, in particular, that changes to terms and conditions of employment. If you haven't got a protected characteristic, a lot of the time as an employer wants to introduce a change. Shift pattern is the obvious one, which we've dealt with here. A shift pattern change. As an employee, you can say to your employer, well, hang on, we signed a contract. You haven't got anything in the contract that does say you can radically change my shift pattern, but you're going to do it anyway. If you haven't got a protected characteristic, historically, you would be left really stuck between a rock and a hard place, because even though a contract is a mutual agreement and one party trying to change it on their own is, unilateral fundamental amendment, which is arguably, illegal in the civil or the contractual sense. It's something that they can't do unless you agree. You are always stuck as an employee with, well, what's your remedy? And your remedy actually is to say, well, by trying to change my terms and conditions against my will, that's a unilateral change. I have therefore been constructively dismissed. Yeah. And therefore I can bring an unfair dismissal claim.
Yeah, so you'd go for unfair dismissal based on, so they've treated you in such a way that they've treated the contract as if it's ended.
For a lot of employees, that's not a great option, right?